And so we thought it'd be a good day to get Cully Stimson on the line, former Deputy Assistant Secretary of Defense for Detainee Affairs. He knows about this stuff, and a senior legal fellow at the Heritage Foundation. Cully, how are you?
Good morning, Brian and Tori.
Good morning. Yeah, you're on with Brian and Tori. So let's talk about this guy, Johar Sarnez. Mm-hmm. He's now apparently talking to investigators, at least through writing, because apparently he has a neck wound and he can't talk.
Right.
Yeah, and first of all, about the Miranda thing. Can you explain to us when you Mirandize and when you don't?
Yeah, you know from your former experiences, Brian, that Miranda applies in two circumstances only. You have to be in custody and subject to official interrogation. And the purpose of the Miranda warning is so that anything he says after he waives his Miranda rights can be used in a trial in the government's case in chief. If you botch up the Miranda warnings, you may still have the information. You just don't have the privilege of using it against him in court in the government's case in chief.
All right, but in a case like this where apparently we hear they have videotape of the guys dropping the bombs off.
Yeah.
You've got good physical evidence.
Right.
Does it matter?
This is not a whodunit. This is a why he done it.
Yeah.
And you're right. It looks like the forensic and other evidence against him is overwhelming. Of course, he's presumed innocent until proven guilty beyond a reasonable doubt in our court system. But really the primary focus here and the reason this debate, enemy combatant, non-enemy combatant debate is going on is whether he should be interrogated for intelligence purposes first, Miranda be damned. And I think most reasonable people think, yeah, of course he should be interrogated for intelligence purposes. And I think that's what's happening right now via these notes he's writing with the high-value interrogation group, the so-called HIG.
But you say Miranda be damned, which is, I get what you're taking, but it's for public safety, right? It is about the public safety. The first 48, 72 hours, I don't know what the time period is, you want to make sure there aren't other bombs out there, they aren't part of a larger
Correct.
cell, those sorts of things. At what point do you stop the public safety criteria and say, okay, now we've gotten what we think we can get out of this guy, now it's time to turn to a prosecution?
The public safety exception, Tori, stems from a Supreme Court case called New York versus Quarles, and it essentially says what you're saying, that you have a limited period of time to question the person absent Miranda to find out if there's another gun out there that somebody could pick up and use, a bomb, etc. It doesn't last a long period of time. There's no bright line rule as, well, it lasts 67 minutes, it lasts 2 hours, it lasts 24 hours. So they have to be careful. The longer they wait, the less effective the public safety exception goes. So sooner or later, probably today since he's already communicating, at most tomorrow, the public safety exception period will end, more likely than not, and then they'll want to Mirandize him. He may still talk after he's Mirandized. We don't know.
I just want to clear something because I think a lot of people think, well, if you don't Mirandize them, then the case gets automatically dismissed.
No.
That's not the case at all. It's just that you can't use anything he says in a court of law, right?
Well, it's even narrower than that, Brian. It's you can't use any statements he says in violation of his Miranda rights in the government's case in chief. But if the guy takes the stand in his own defense, you can cross-examine him and impeach him with the stuff you took that you got pre-Miranda. So
but if you have evidence that's outside of the Miranda that you developed independently that makes a very compelling case, it's just not that big an issue, right?
I don't think it's an issue that's going to trouble law enforcement in this situation at all. And frankly, this chatter by some people saying he should go to a military commission is just ignorant. I mean, you cannot be a citizen and subject to military commissions. Look at Rule 202A. You have to be an alien. That means a non-citizen. So he is not going to a military commission, period. The law is very clear on that.
So where do you think this ends up? At what point do we shift to the prosecution side of this?
Well, the wheels of justice are already moving on the prosecution side. I suspect the indictment is drafted. It's going to include material support to terrorism, using a weapon of mass destruction, i.e. a bomb, causing death. It's going to probably use a conspiracy charge and, of course, murder, not only of the police officer but of the people at the marathon. So, when he is presented before a federal magistrate as a matter of sort of common sense, they could bring the magistrate to his broom. They could present him in court by bringing the court to his bedroom, that may happen in the next few days. It's going to happen very quickly, Tori.
Right. And talk about the broader context, Cully. I mean, I keep saying, maybe this, as tragic as this is, maybe this is a wake-up call. And I'm happy to use the words war on terror because I think we are engaged in an ongoing war on terror. Maybe this is a sign that, hey, these are the kinds of threats we have to really be thinking about because they're there and they're very real. But what's your sense of the broader context of what happened? Or is it just an isolated incident and we should deal with it in that matter?
Well, it's clearly yet another attack against our country. This one was successful, unfortunately. We've had numerous unsuccessful attempts. I mean, the list goes on and on and on. Times Square bombing, Christmas Day bomber, Fort Hood shooter, Nidal Hassan, etc. And it just simply means that we are engaged in an armed conflict, some of which is domestically related, some of which is inspired by Al-Qaeda, some of which is directed by Al-Qaeda, the Taliban, or associated forces. And we have to be vigilant, but we have to keep the counterterrorism tools in place that work, but we can't stop being Americans and living our lives.
All right, Cully Stimson, former Deputy Assistant Secretary of Defense for Detainee Affairs and a senior legal fellow over at the Heritage Foundation. It's very enlightening and very helpful to have you here today. Thanks for joining us.
Thanks, Cully.